Good evening, everyone, and welcome to Bounce Back Thursdays. Keeping in line with our ongoing Bouncing Back and Going Beyond 2020 campaign, this is a weekly talk aimed at empowering you with the information you need and helping your business bounce back from the challenges of the COVID 19 pandemic. The topic for the month is money recovery. Earlier, we covered several subtopics under money recovery. If you missed it, the links to those videos are in the description. Now, if you're having any problem with money recovery, there is a Google form in the description. Make sure to enter your contact details in the form. At the end of the month, we're going to shortlist a few people and help them send legal notices to concerned parties completely free of cost. So make sure to enter your contact details in the form. Now, the topic for this week is procedure and processes under Insolvency and Bankruptcy Code. Joining me today is Mr. Antim Amlan. He's the manager for growth and strategy here at Vakilsearch and also the subject matter expert. Welcome, Antim.
Hi, Ranay. We meet again to discuss further about the Insolvency and Bankruptcy Code. So let's just start.
Excellent, Antim. So thank you for joining us. So as you rightly said, let's get started. So I think it's best that we recap what we talked about a little bit about what we talked about last week. So can you give us a recap about Insolvency and Bankruptcy Code?
Yeah, sure, Ranay. The Insolvency Bankruptcy Code 2016 was enacted to help solve the major NPA problem in India. Mostly, it changed the effect of law from a debtor pays to a creditor control regime. It 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 instituted the official regulator, which is the Insolvency and Bankruptcy Board of India. Then it brought a entire system of recovery of money, and it brought a new set of professionals called as insolvency professionals, and uh, and it made it easy for the creditors, which are of basically two types, that is financial creditor and operational creditors, to recover their money in a much better time bound process in by the enactment of this law.
All right, very succinct. So let's talk about the difference between financial and operational creditor.
Yeah, sure. So operational creditors are and financial creditors are both defined in the Insolvency Bankruptcy Code very clearly. Uh, Operational creditors basically are defined under Section 5, Clause 20, where it says that any person to whom an operational debt is owned and includes any person to whom such debt has been legally assigned or transferred. So to put it, to explain it in a much easier way, you can say any person who is providing products and services and has debt or owes any form of debt in return is basically a operational creditor. In the same tune, a financial creditor is also defined under Section 5, Clause 7 of the Act, which states that a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. Okay. Then, furthermore, the financial debt is defined under Section 5, Clause 8, which says that financial debt is basically any money borrowed against payment of interest, or basically any loan or any credit facility, okay, including bonds, notes, any form of securities as well. Okay, so this is basically the difference between financial creditor and operational creditor. Also, in terms of procedure, there is major differences between the two types of creditors under this act.
All right. So in that case, let's go into this procedures. Can you talk about the steps and procedures involved?
Yeah, sure. I'll first deal with the operational creditors, the processes and procedure involved for them. Then we'll move to the financial creditor.
Okay.
At one, the entire process under this particular act can be broken down to three steps basically. Okay. First step is the initiation. It is called as the initiation. Is basically when a default occurs and the resolution process can be started by the creditor by putting up an application to the adjudicating authority. And as we discussed in the previous video, the adjudicating authorities instituted under this particular act are called National Company Law Tribunal, right?
Okay.
Now the second step is is basically the decision to resolve the insolvency. Okay. Once the adjudicating authority decides if there is a particular debt owned or not, If there is a debt owed, then it passes the order, and then the next step goes to the committee of creditors and appointment of a insolvency resolution professional.
Okay.
Then the third step basically is the liquidation. Okay. So as per the decision of the committee of creditors, this liquidation happens, or if the committee of creditors fails to decide upon anything, then also the liquidation is ordered by the tribunal itself, right? So these are the three basic steps that is provided under this particular act. Now going further into the detailed steps of how a operational creditor may start his application. So in case of an operational creditor, the procedure is defined under section 8 and 9 of the Insolvency and Bankruptcy Code.
Okay.
So section 8 talks about a demand notice. Okay, very similar to that what we discussed under the Negotiable Instruments Act and check bounce cases, right? It basically gives the provision for a demand notice, very similar to what we discussed under the Negotiable Instruments Act for check bounce cases.
Nice.
So this demand notice should be sent to the operational debtor by the operational creditor, involving and including all the details of the copy of invoice or details of the default, and in the manner prescribed under this particular section. And the section 9 basically talks that after an expiry of 10 days from the date of delivery of the notice, the operational creditor may file an application if the debt is not paid. Okay, so the application has to be made to the National Company Law Tribunal, having jurisdiction over that particular dispute, and it should be made under the manner prescribed under section 9 of this particular act. Now, unlike the procedure for operational creditor, financial creditor does not have to send a demand notice. Okay, the procedure is defined under section 7 for the initiation by a financial creditor, and the financial creditor can directly file this application before the National Company Law Tribunal. Okay. However, there is a manner prescribed, and by paying the requisite court fee, the financial creditor can apply to the National Company Law Tribunal. However, the financial creditors have been defined by the National Company Law Tribunals, National Company Law Appellate Tribunal, and the Supreme Court, where a particular attorney, only after studying the nature and facts of the case or of the debt, basically, can help you understand whether you as a creditor will be falling under the meaning of financial creditor or not. Okay. And very recently, to give you a perspective and understanding that the Supreme Court rendered the home buyers, okay, as financial creditors, which led to a lot of cases being filed with the Supreme Court by the homeowners who were not getting possession of their flats within a typical time. But again, the builders also approached the Supreme Court to help solve the issue, because a lot of builders were rendered as insolvent under this particular process.
All right.
Right. So this is how the procedure for both the types of creditors is basically defined under this particular act. However, I will also put it in effect and say it over here that the right to representation for the operational creditors is little lesser, or I would say much lesser than that of a financial creditor.
Okay.
How does it work? That after you have put an application, and let's say the NCLT is satisfied that there is a debt, and then it gives the order to start the insolvency resolution process. Okay, after the order of the NCLT, insolvency resolution process is started, and a time of exactly 180 days, okay, from the date of admission of the application, a time of 180 days is given to complete the insolvency resolution process. It is in short called CIRP. which stands for Corporate Insolvency Resolution Process. The first thing that happens under this is basically appointment of the insolvency resolution professionals. Okay. Now we will discuss the entire resolution process in detail in the upcoming videos.
Right.
Okay, but just to clarify that after this, a committee of creditors is formed by the insolvency resolution professional. So in this particular committee of creditors, the financial creditors are given more opportunity, or given the opportunity to be a part of this committee of creditors, and the operational creditors are only given such allowed such opportunity if the aggregate dues are more than 10% of the total debt. Okay, so in that case, the operational creditor can send a representative to the committee of creditors. However, the operational creditor will not have any kind of voting rights. So yeah, so coming to the question as what does the committee of creditors do? We will discuss it in the next video in much elaborate manner. But to put it very briefly, the committee of creditors has the task to come up with a resolution plan. Okay. And the resolution plan basically gives the way of settlement of the debt to the creditors by either by selling of the assets or in any other form of liquidation. That's all.
Okay, Antim. So looking forward to connecting next week to talk about steps involved in insolvency and resolution process. So until then, thank you. Take care.
Thank you, Ranai.